So today we are going to start with the unit 13 of module B, which is the laws relating to securities and mode of charge, part 2. In the part 1, we have completed the mortgage and the different types of mortgage. Today we are going to see appropriation, assignment, hypothecation, pledge, banker's lien and set-off. So let us begin. First type, we have appropriation. Simply, if we try to understand appropriation, if let's say one borrower has taken multiple loans from one creditor, let's say a bank. All right. And when they make a payment, let's say loans were taken of rupees 1 lakh, then another loan that was taken of rupees. In the part 1, we have completed the mortgage and the different types of mortgage. Then in another year, we say the loan that was taken of 1 lakh rupees was in the year 2015. Then in 2016, another loan was taken of rupees 2 lakhs. Then 3 lakhs loan was taken in the year 2017. So here the same borrower and same creditor are entering into these agreement. Now if this borrower makes a payment of rupees 2 lakhs of rupees 2 lakhs or let's say 1 lakh in the year 2018. Now they will have to state to which of these three loans will the amount that is paid will be appropriated. That is the process of appropriation. All right. So if the borrower is stating that use this amount to make the payment of the first loan, it is the appropriation made by the borrower. If they're not making any intimation about this, then the creditor can on their own discretion make the appropriation accordingly. And if none of these or neither the creditor nor the borrower are making the intimation, then it will be by law. It will be by law and proportionately the loans will be appropriated. So now we see the formal definition. So in law, where a debtor and a creditor are involved, appropriation is the application of a particular payment received from a debtor for the purpose of repayment of a particular debt. So the debtor or the borrower, they are stating that use the payment to make the repayment of a particular debt. In other words, it is the setting aside of funds. This is the meaning of appropriation. Now, there are three important sections under appropriation: 59, 60 and 61. Section 59 says where a debtor owing several distinct debts to a person makes payment to him either with express intimation or implying that the payment is to be applied to the discharge of some particular debt, then the creditor has to accept it. The payment should be accepted and must be applied accordingly. So the first priority of making the implication or intimation for the appropriation lies with the debtor, right? Then if the debtor has omitted to intimate or there is no condition that states that the payment has to be made in a particular discharge of a particular debt, then the creditor may apply it at his own discretion. All right, so section 60 says discretion with the creditor only if the debtor has not stated any particular debt to be paid off. Now, this is whether or not it is barred by the law in force at the time of being to the limitation of suits. So, when the creditor is using their discretion, they will try to pay off a debt that has that is close to the time bar, right? Or that has a lower rate of interest. Or when a debtor is trying to pay off a debt, they will pay off a debt that has a higher rate of interest, right? Similarly, they will use their discretion. If none of them make the appropriation, if neither party makes an appropriation, then the payment shall be applied in discharge of the debts in order of time. In the order of time. So the law will apply here if neither the creditor nor the debtor are making any appropriation. Whether they are or not barred by the law for the time being in force, the payment shall be applied in the discharge of each proportionately. All right, so either in section 59, discretion of the creditor, discretion of the debtor, section 60, discretion of the creditor, And section 61 talks about the law when neither party makes an appropriation. This is the charge of appropriation between the creditor and the debtor. Then we have the assignment. Assignment, the most popular example of assignment is where the loans are taken on the insurance deeds. The insurance deeds. So if a person is keeping the insurance paper or the insurance deed for, let's say, a house loan, a housing loan was taken and insurance on the house was given as the mortgage, or it was given as a security, not mortgage but security. All right. So if here the borrower and the creditor is there, the borrower will say, if I fail to repay or there is a default in the payment, then the proceeds can be generated from the insurance company or the insurance paper or contract. All right. Another example of assignment is where three persons are involved. Three persons are involved, and the contract is between two people, but a third person is transferred the rights to make the payment. So here the transferor and the transferee, or the assigner and the assignee relationship will exist. So assignment means the process by which a person called the assigner prefers to transfer rights or benefits to another person called the assignee. However, there can be no transfer of duty, burden or any other detriment without the express agreement of the assignee under assignment. So the assignee to whom the transfer of rights is being made, they should have the express agreement to it. And only the assignee can have only the rights equal to that of the assigner and cannot have better rights. This is another important point. All right, this is another important point. Another example of assignment can be if, let's say, A owes a debt to B and B owes a debt to C. So B can say that A, you make directly payment to C. So that is also a type of transfer of the rights. All right, this is there. Then the third type is a pledge. A pledge. Pledge is a relationship which exists between the pawner and the pawnee, the person who is bailing their goods. Pledge basically means the bailment of goods for the purpose of providing security for a payment of debt or performance of promise. In bailment, what is happening? The goods are transferred for use for a particular period and then they are returned. In pledge, what is happening? The goods are bailed but to be kept as security. For example, when the borrower goes to the lender, a bank, and asks for a loan, the loan is advanced in returns of the pledged goods. So the possession of the pledged goods is transferred as the collateral security for the repayment of debt, like securities, jewelry, or negotiable warehouse receipts, and these can be used by the borrower. The legal possession is passed, but they are still used by the borrower. They can still have the jewelry or the gold. So the best example of pledge is against gold jewelry. All right. So the person whose goods are bailed is called the pawner, and the person who takes the goods as security is known as the pawnee. This is the pawner-pawnee relationship, which is similar to the bailer-bailee kind of relationship, the bailment of goods for the purpose of providing security. So a special interest in the movable properties pledged passes to the pledgee by the virtue of bailment, but the ownership remains with the pledger. The ownership is still with the pledger. The pledger can use it. They can use it. And if the debt is not repaid, then the pledgee or the pawnee can make a sale of it. All right. They can have the right to take away the goods or its price. This is the pledge. Then we have hypothecation. Hypothecation, wherein the charge is created upon any movable property. In mortgage, we studied the charge was created on the immovable property, but in hypothecation, it is made upon any movable property. Now, a very important question that has been asked in the previous examination, under which act hypothecation has been defined? So, this term came to be defined in the Surface Act of 2002. So hypothecation means the charge created upon any movable property existing or future. Another difference, right? The goods can be existing or future, created by a borrower in favor of a secured creditor without delivery of possession of the movable property to such creditor. So there is no delivery of possession in hypothecation. As a security for creating the financial assistance includes floating charge and crystallization. This, the difference between fixed charge and floating charge, and what is the effect of crystallization or the floating charge changing into a fixed charge, we will be seeing in the next chapter, where we study the charge registration and non-registration of charges. All right. So what is happening under hypothecation? Basically, the hypothecation, it is different from mortgage. Although the immovable property is kept here, the mortgage relates to the immovable property, hypothecation relates to the movables. And in the mortgage there is a transfer of interest in the property, but hypothecation involves only an obligation to repay the money, and there is no transfer of interest. Only an equitable charge is created in favor of the lender or the creditor, right? So there is no transfer of property. That is why this hypothecation is limited only to the respectable customers, because it is only an equitable without any possession. So if a question is asked why or in which type of charge only the facility is limited to the respectable customers, so we know it is hypothecation. Why? Because it involves only a charge, an equitable charge being created without any transfer of possession. So where can hypothecation be used? Let's say when the loans are raised against work in progress, or we will say if a particular person A has a factory or a showroom of any goods, let's say car, and at any time 20 lakh worth of cars is always there. So the bank can say you can continue with your usual business of buying and selling cars, but on this minimum level which is always maintained, we are creating a hypothecation. So it is ongoing, a work in progress. For example, rice mills, oil explorers, etc. Right? And it is convenient. Then we have the banker's lien. Banker's lien, it is the right of the banker to retain possession of the goods and securities owned by the debtor until a debt due from the latter is paid. So it is an implied pledge. Basically, the banker acquires the right to sell the goods which came into his possession in the ordinary course of business in case a debt is not paid. Let's say the person A had taken a loan from the bank, any bank, let's say bank ABC, and at the same time they had also kept their money in a deposit account, in a deposit account. So the bank will have a right on this deposit account if there is a non-payment of debt, a non-repayment of debt. So the banker has absolute right on a general lien on all the goods and securities that are received by the banker. So the bank can then recover the amount, right? So that is a banker's lien. That is a banker's lien. So the banker, now this term that is given here, they're acquiring the right to sell the goods which came to his possession in the ordinary course of business. So if a customer by chance they leaves a packet containing certain share certificates or life insurance policies or fixed deposit receipts while they're leaving the bank premises, then the banker will have no right of lien. Only through the normal course of business they can create this right. So the property must come into the hands of the bank in normal course of business. Then it should not have been interested for any particular purpose. This possession should be lawful. So this is the banker's lien. And then we have finally set off. What is set off? Basically what we are doing, we are cancelling out. So it is the right of a debtor to take into account a debt owing to him by a creditor when claiming a debt due from him to the creditor. What is happening here? The right of a debtor to take into account a debt that is owing to him by a creditor. So if A and B, they have taken loan and given loan to each other, then they can cancel it off. So in the case of a banker, the right of set off enables him to adjust the debit balance in the customer's account with any balance outstanding to his credit in the books of the bank. So the banker can adjust his claim from the amount that is payable to the customer. Now here what is happening? In the banker's lien, the right was there that the bank can sell off any goods that were entrusted with him in the ordinary course of business. In the set off, the bank has the right to offset or deduct a debt that is owed. Right? They can offset or deduct a debt that is owed. So the loan account and the deposit account can be set off. They can be set off. This is the meaning of a set off agreement between a bank. Now, the bank or the creditor, they cannot use both the rights together. They can either use the lien, banker's lien, or the set off. They cannot use both of them together. Also, the debt that is occurring due cannot be set off that against a debt that is already due. Plus, the credit balance in the account cannot be set off against a contingent liability. And whenever the account cannot be debited until the demand is actually made late or the due date has actually arrived. So these are certain conditions or salient features of a set-off. However, automatic right of set-off also arises if, let's say, there's the death of the customer or insanity or insolvency, on the insolvency of a partner of a firm or winding up, or on the receipt of a garnishee order or assignment of a customer's credit balance. Here the automatic right of set-off will be given to the creditor or the bank. So that is all. We have summarized the different types of charges that can be created. You can also join the selection batch, the CAIIB selection batch for June July 2025, which is an all-in-one course for all the papers for your July session. And these will be available both in English as well as bilingual medium, along with the downloadable study notes, sectional tests, case study, and elective paper test. If you enroll now, that is before 19th Jan, and use the code special SPL, you will get flat 49% off on the JIB as well as CIB subscription. This is the Mahakumbh special package, right, for the Super Elite plan and the selection batch. So that is all for today. We have completed this chapter. Tomorrow we are going to study the charges and registration of it, with which we will cover the module B, and the module B will be finished. So thank you so much for attending. If you have any doubts, any queries, you can let me know in the comment section. Make sure that you subscribe to the channel so that you do not miss any of the updates. Thank you and